Hey everybody, welcome into the back room. I'm Andy Ostroy. We have Mimi Rocah back with us again. We'll chat with Mimi in just a second. But first, thanks for tuning in. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and/or post on our social media, and we'll read some feedback next time. And if you like the podcast, please rate and review and follow or subscribe, and you'll be notified every time we post a new episode. So Mimi Rocah is an attorney who served as district attorney of Westchester County, New York, from 2021 to 2024. Prior to becoming DA, she served as an Assistant U.S. attorney for the Southern District of New York for nearly 17 years, where she prosecuted and oversaw cases involving violent crime, organized crime, human trafficking, sex trafficking, child exploitation, frauds, and public corruption. She's a frequent commentator on MSNOW, CNN, The Contrarian, Cafe, and numerous podcasts and radio shows on topics relating to law, justice, and women's issues, and she has written and published dozens of opinion pieces on those subjects. She's an expert in the rule of law, democracy, and the corruption and abuse of the justice system, and is currently an adjunct professor at Fordham University School of Law. And she's writing a book, Justice Under Siege, about the Trump administration's political takeover of the Department of Justice and the heroes who have stood up. The book is due out September of this year. Mimi, welcome back into the back room.
Thanks, Andy. Great to be here again with you. Talk about crazy stuff again.
Yeah, so let's discuss Trump's latest stop on his revenge tour, which is the new indictment of former FBI Director James Comey. This is over a post he made, I think over a year ago, on the beach. He was walking by. He didn't even position the seashells. He just apparently walked by and found these seashells formed with the numbers 8647, which the administration now claims, of course, that was a threat on the president's life. So the charges are that he is making a threat against the president and transmitting a threat across state lines. As charges go, these are pretty serious, correct?
100%. The statutes cover very serious conduct that I've charged and debated charging and often wanted to charge and couldn't because, some of the limitations of the law that we'll talk about with, frankly, far more egregious conduct than this. But yeah, I mean, obviously threatening a president and threatening people through interstate commerce, i.e. over the internet. I've had cases where people's lives were ruined, because they were so traumatized or living in fear by threats. This is not that fact pattern, though, as we'll discuss.
Yeah. So in your opinion, as a former federal prosecutor and a district attorney of Westchester County, former district attorney, how bogus is this indictment and these charges?
It's hard to even find the right level of outrage about this indictment, and that's, after many, many months of things that I thought had hit the limit of outrageous use of DOJ's power and resources. It doesn't pass the smell test. It doesn't pass the laugh test. It is pretty clearly based on all of the circumstances, i.e. Trump's call to prosecute Comey, which we knew about because he made it public to Bondi, the prior attempt at prosecuting him on also very, very flimsy legal and factual grounds that was dismissed. The apparent, we never got the full reading of it, but we got some taste of kind of what went on in the grand jury in those cases, because the judge talked about, some instructions to the grand jury by the prosecutors in those cases that were wrong and illegitimate. And so all of that, and now this indictment based on this silly factual and not legally sufficient predicate just cannot lead to any conclusion other than they were trying to harass the heck out of Jim Comey and his family. And, it's really, vindictive has a legal meaning, and that I'm sure we will see a motion about here, as we were going to did in the prior attempted Comey prosecution. But it also has a colloquial meaning. Like, this is mean-spirited. It is an attempt to say, we're not stopping. We're not going to just let you get off the hook because you got one case dismissed. We're going to keep coming back. And Comey acknowledged that in his remarks last night. He said, they're at it again, and this won't be the last. And I think he's right. And frankly, with each prosecution, each successive attempted prosecution, that vindictive prosecution claim in court gets stronger.
And likewise, does it make it easier for future grand juries to say, you're here again? Like, really? Like, or can they just, indict the ham sandwich as?
Yeah, I think at the grand jury stage, it has less relevance for a couple of reasons. One, arguably, the grand jury doesn't know. It's not necessarily something that is brought before them. I know we know everything that's going on, every twist and turn with DOJ, and many of your listeners do, but not everyone in America is following it that way. Mm-hmm. And, I have been before plenty of grand juries where, you ask questions to sort of suss out, their knowledge or bias, potential bias, and it's just not necessarily what we would think. So they may not be aware whereas in court, when we're talking about a vindictive prosecution motion to a judge, it is, first of all, most judges probably are aware of it, but also it is the obligation and the right of the defense attorney, Comey's attorneys, to bring these cases to the attention of the judge. But I will say, I do think that we've talked, and you've talked with other guests about the loss of this presumption of regularity in the courts for DOJ, right? There is this sort of established doctrine that the Department of Justice, when a representative says something in court to a judge, it has a presumption of truthfulness. And it's not that can't be rebutted and that a judge has to take everything at face value, but you sort of start with that. And there's a presumption of regularity in the grand jury, i.e. when you come to a judge assumes that you did things properly as a government attorney in the grand jury. You properly instructed them. There's a lot of trust that goes on because, prosecutors are in there by themselves, right? There's no defense attorney, right. There's no judge. But part of how, for example, in the first Comey case, they were able to have the judge inspect the grand jury proceedings is because they overcame that presumption of regularity in the grand jury. And I think that's going to happen here as well. And we are seeing, we've seen plenty of examples of grand juries rejecting charges in other cases, totally separate from this one, but where there does seem to be, particularly in certain jurisdictions like Washington, D.C., where there are so many cases being brought that are just preposterous, that the grand juries do seem to be starting to say what you said, like, hey, wait a minute, really? We're not going to give you the level of trust that we have given in the past to government attorneys. And I think that's completely earned and warranted, this sort of degradation of the presumption here by this DOJ, because they are not doing things regularly, remotely.
Right. So getting into the micro of this from a legal standpoint, when this happened, he immediately took it down the same day. He apologized. He said, I had no idea that some people look at this, 86 thing as suggestion of violence, So in law, I'm not a lawyer, you are, right? There's ambiguity of any one of us who's worked in a restaurant knows that 86 means like we're out of French fries, so what is the intent there? And that's the second thing that's really important, right? Is intent. They'd have to prove that he intended to threaten the president of the United States.
Look, based on what we know so far, it's going to be not possible for them to prove the requisite level of intent. And in fact, the indictment here doesn't even cite the proper statutory intent requirements. Um, and, I mean, they don't have to copy the language of the statute, but that is how prosecutors usually plead cases. Like you put in, knowingly, willfully, intended, whatever the language from the statute, I mean, you almost always put that in the statute. And the fact that they didn't here, I think, is either telling that they don't understand what the requirements are, but all they had to do is look at the pattern jury instructions. There are sample jury instructions out there, right? In every circuit, in every area. And this is the Fourth Circuit where this district court, where this grand jury and the district court sit. And I've looked at those jury instructions that a judge would say, if this were now going to trial, okay, jury, here's what you need to find, right? And this indictment doesn't even attempt to sort of meet those standards of showing a true threat and showing and that's a legal language from a Supreme Court case, and that a rational person would I'm just looking for the exact language, that the true threat, whether a statement, which is, this is from case law, ordinary, reasonable recipient who is familiar with the context in which a statement is made would interpret it as a serious expression of intent to do harm. Mm-hmm. So, for example, I'm looking at, one of the pattern jury instructions from this court area. And for the interstate threatening communications, for example, which is the second count, they have to show that the defendant, transmitted the communication, that he subjectively intended the communication as a threat, which is the part that you were talking about, that they have to show that Comey's state of mind was, this is a threat to kill Trump, and I am intending it as such. There's just no way to prove that unless there's some evidence that we don't know about. But on the face of it, and based on Comey's statements afterwards and his taking it down, and the ambiguous nature of the statement itself and how it does mean different things to different people and has several different definitions in the dictionary and online, there's no way to prove that. And third, that the content of the communication contained a true threat to injure. Again, that gets, and that's language that courts have expanded on, this true threat. There's just no way that a reasonable person, which is always the standard we use under the law, could think that taking a picture of seashells of, this, again, ambiguous language that in fact means something completely different to many people in different contexts is a true threat. And then the threat for the other count, again, they have to show that the defendant knowingly and willfully, right, made the threat. And the knowing and willful part here is just, it's not there. They don't even attempt to put it in the indictment. And I will say, Todd Blanche, the acting attorney general, has been, out there in his press conference. I saw a clip of him on CBS News. I'm sure he was on other things trying to defend this because it's under attack from very conservative commentators, legal commentators like Jonathan Turley are saying this isn't going to fly because of another issue, which we haven't even talked about. Like, if you can't meet the elements, you have a serious First Amendment problem, right? It's protected speech if it isn't a true threat.
Right.
And so that's why, everyone talks about it in terms of this isn't going to fly under the First Amendment, including, for example, Jonathan Turley, Andrew McCarthy, all sorts of conservative legal commentators. Blanche has been out there kind of, I will say, implying, insinuating that there is other evidence that he's not going to reveal because that would be prejudicial to the defendant. I just don't believe that, quite frankly. And I don't say that lightly, that I don't believe something from an acting attorney general. I don't believe something from this acting attorney general, from Todd Blanche, and what he has done since January 2025, and outright false statements that he's made, and his desire to, seemingly please Trump. And I think if they had evidence, they would have shown it by now, because again, they need to defend this. They're coming under attack for it, for bringing this indictment. And also because it's really hard to even imagine what such evidence could be. They keep talking about doing this investigation, looking at Comey's phone. Look, if I'm wrong, I'm wrong. And if they have some evidence, let's see it. I can't really even imagine what that would be.
Yeah, well, he would have to have made statements or sent texts or whatever that, support this indictment. And that just seems so ridiculous. It almost seems ridiculous to be analyzing this the way we are, because but we are living in crazy times, so it's important. But the fact that he came across these shells instead of positioned them himself, doesn't that make it even like 1,000 times harder to prove intent? Because then you have to say, like, this man who wanted to cause harm to the president just happened to walk along the beach and see shells that were laid out in a manner that supported his own intention. Like, that just seemed like...
Right, like he went to the beach with the intention. He
like,
saw
holy
something
shit,
that supported,
shells.
Or that he instantly formed the intention right there. So I think that, look, I think even if he had created this shell formation himself, we would be having lots to talk about still. But yes, absolutely. It is much more of a random happenstance, spur of the moment, non-intentional act, misguided. I don't love that he posted
totally
it,
misguided.
given everything, right? But like, that's not a federal crime.
Right.
And it's not a felony. And, I remember when he posted it and I thought, really, and I know Jim, and there are a lot of things I like about Jim and respect. I mean, he was a U.S. attorney when I was a prosecutor, after 9/11.
He's made some mistakes. Let's just say that.
He's made mistakes, but he also was a great leader to our office right after 9/11 in a very perilous time, to the Southern District of New York. He helped, lead us through that. And, I know people in his family, and, there are plenty of good things I could say, but I looked at that and I said, really?
Yeah.
Well, posting that?
Let me ask you this. We now know, or we are reminded, that former Congressman Matt Gaetz had posted something similar with the term 86. The alt-right conservative commentator, Jack Posobiec, literally posted 86-46 about Joe Biden. Does that help from a legal standpoint? Is that going to help Comey?
Yeah, again, because it certainly takes away from the idea that someone should have known I say that as if it is, should have thought that it was an actual lower threat to kill someone or to cause violence. Because if it were, the Department of Justice would have investigated and likely charged those people and many others. And, this isn't as much, you're raising all the right legal arguments that Pat Fitzgerald and other excellent attorneys will have a field day with. And there's also just the complete hypocrisy of it. Not sure how this comes in, but Donald Trump himself has made and said and posted things that frankly are far more explicitly threatening to
Joe
many
Biden in the back of a pickup truck,
including Biden, right?
Bound and gagged, like.
I'm not sure. It could play into a selective prosecution motion, although they have many other, frankly, better examples of that. But it makes it all the more enraging when I hear Todd Blanche standing up and Patel and saying in front of the DOJ seal, we will not tolerate any threats of political violence. Like, okay, except for when it comes to your apparent, the man you love, Donald Trump, who you've pledged your love to.
Yeah. Well, let me ask you this, because Todd Blanche was on TV, I think it was this morning, talking. One of the reporters asked him specifically about Matt Gaetz's post and Prosoviec's post, and he's, of course, said, well, that's different. That's different, and you have to assume that we have done our due diligence and investigated when Comey did it, and we have reason to move forward with this investigation. And to your point earlier, it's like, well, what could they possibly have? Is that just bullshit that he's spewing? I am willing to bet every dollar that I have that they don't have anything concrete that proves any intent whatsoever that James Comey intended to threaten Donald Trump. So that then means that Todd Blanche and whoever else is commenting on this is lying. And that, again, speaks to the hypocrisy you just talked about. Like, it's okay if Gaetz does it and Prosoviec does it, but not.
Yes. And I will say this to maybe give a little bit more, even more credibility to the point, which is I am one who tends to see the good in people and believe them. I mean, some might call that being naive. And at times I am, don't worry. I usually get over it. But I really do have a prosecutor's approach, an investigator's approach. And so if someone says something, unless it's, patently false, I try to take it at face value and see, is there something that contradicts that? And given that I used to know Todd Blanche very well, under other circumstances, not the world we're living in right now, if he said something like that, it's oh, well, Todd wouldn't say that unless he had it. There is no question in my mind anymore. And I've been working on a book on, for the past 9 months, looking at the decimation of the Department of Justice. And Blanche has played such a central role in that and has become, I think, quite comfortable with saying things that, I'm not going to use the word lie, only because I think he is evasive. He finds ways to talk around things and not answer specifically the question. And so I think if we pick apart what he actually said in the press conference, he never said, we have evidence. He insinuated it. He made it sound like, oh, we've been investigating for so long, and the cell phone. So, I mean, that's not good. I'm not defending it. I'm just saying that's, he created a false impression, I believe.
I mean, the fact that he brought this indictment, doesn't that just de facto mean that there's evidence? Right? So
No. I mean, what it means is that
should mean.
Should mean 100%. Yes. And again, back not that long ago, 2 years ago, whether it was a Republican or Democratic president, whether it was, Bill Barr, frankly, or, Janet Reno, I would have said, all right, they got an indictment. They must have some actual evidence of this, because I don't know federal prosecutors to go into grand juries without the sufficient evidence to not only obtain an indictment under the legal standard, but confidently, know that they can, not 100%, you never know 100%, but that you're more likely than not to win at a jury level where it's a higher standard of proof. I don't have that faith right now. Just like we were talking about, judges have said, you DOJ have lost the presumption of regularity. I think they've lost it with the public. They've certainly lost it with me. And I just have no reason to think right now that this grand jury was properly instructed. I don't know what they were told about First Amendment protections, about the actual legal standard. And, grand juries are only as good as the information they're given and the integrity of the prosecutors before them. So I think if there is a motion that is successful to get access to the grand jury information, or at least to have the judge review it, that could be very, very telling. But there's also the issue that this indictment, even putting aside what happened in the grand jury, there is a good chance it gets dismissed for failure to adequately state a claim on its face, which is a really, really hard motion. And so I don't want to like set expectations up that that is going to happen, but I'm saying there's a realistic possibility of it here, which I would almost never say in most regular DOJ drafted indictments.
So that was going to be one of my last two questions. And that is, what does happen next? Is there some kind of motion to dismiss? Like if you were representing Comey,
Yeah.
what's the move here?
Yeah, I mean, there's a lot of motion practice, and one of them absolutely is this indictment doesn't state a claim, essentially. It doesn't properly plead an actual felony on its face, and what it pleads is protected by the First Amendment, period. And there's a lot more nuance to it, but that's the essence of it. And I think there's a pretty good argument that a judge would at least take that really seriously. Then, of course, there is, again, as we were discussing, a vindictive prosecution motion, which, again, used to be really, really hard. No one almost ever won them. I think Comey would have won it in the last case, and I think now he's got a frankly even better argument because of the successiveness of the charges. Mm-hmm. There are certainly, I'm sure they will have other motions to file. I mean, these are the ones I'm thinking of right now.
Mm-hmm. Last question. So we know that over the last year, a lot of judges have excoriated the Trump administration, the lawyers. I mean, harsh language. We know from the first Trump term that a lot of his lawyers were disbarred, sanctioned. There was consequence to walking into a court with bullshit. Do you see that happening again at some point down the road? Like, are they just marching down the same path that they did before? Just different players, different names, faces, but they're going to end up in the same place? Because I would imagine you can't do this stuff.
Yeah, and I mean, I do want to draw one minor but I think important distinction, which is in the first Trump administration, the people who ended up being penalized for their conduct as lawyers were the people not really in the administration. It was the people in the end who were defending these frivolous, meritless claims about the election. The actual people around him, including Bill Barr, for whatever reasons, and I'm not trying to convince anyone, I'm not trying to defend Bill Barr, but I'm just saying there were lawyers in the official positions who drew the line at, I'm not filing frivolous claims, like saying the 2020 election was rigged and stolen when it was not. Here, the difference is these people are in official Department of Justice positions. Pam Bondi was doing it. Todd Blanche is doing it. They are bringing and defending what I consider illegitimate, vindictive, political cases, and they are spreading political propaganda on behalf of Trump. I mean, look at the motion about the ballroom that was filed that I'm sure you've seen people mocking online. It's not just that it was badly drafted. It's that they are putting Trump's theories about everything into DOJ documents. And I really, really think that that kind of conduct where you're in an official capacity doing things like this is frankly even more serious than a lawyer outside of the government.
Right, which should make it prone to consequence, even more so than what a Rudy Giuliani was doing.
Exactly. No, I mean, that would be my argument. Like, this is really an abuse of their power. Anytime a lawyer does it, it's an abuse of their oath and their power as an attorney, but that's still different than being a government lawyer doing it. So
it just seems like, to circle back to what you said earlier, like they know all this, right? It's really about what you said, which is to harass James Comey or anybody else, Letitia James or whatever, make their lives miserable, cost them time and money, sleepless nights, whatever. That's the goal, not conviction, right?
I mean, I think that's right. I did think that Todd Blanche was different from Bondi in that he knows what will fly, and I thought, and not fly in an actual court of law. And so that's why I think we have heard things previously about him pushing back on things. I didn't really think it was on principle. And I'm not saying it was a lot, but there have been some examples cited in the press. And I always thought, well, that's because he knows it's not going to actually succeed. And he knows that Trump doesn't like failure. This, to me, disproves that theory, because I don't see how this succeeds. And I don't see how he does not end up looking really, really humiliated by bringing this. Again, he's insinuated he has some other evidence. Let's see it. But right now, I would say, yes, they seem not concerned with the actual merits or how it turns out, but satisfying this incredible, unending desire on Trump's part to get the charges brought, and put Comey, more than almost anyone except maybe Brennan, under, real pressure.
Mimi, thanks so much for helping us try to understand this, although a lot of it is just not understandable.
It really isn't.
Come back soon.
Andy. Thanks
Take
so
care.
much. Bye.
This episode was produced and edited by me, Andy Ostroy. It was co-produced by Maddie Rosenberg and Jen Hammoud for Radio Free Rhinecliff, with additional editing by Maddie Rosenberg, music by Andrew Hollander, and graphic design by Cricket Langale. And with a special thanks to our sponsor, The Epicurean. Again, thanks for listening. Please rate and review wherever you get your podcasts, and subscribe to the Backroom with Andy Ostroy YouTube channel, where you can watch full videos of our interviews. See you next time.